Good day everyone, I am Alexa Visitera, and for today I am going to report to you about the rights of test takers under Chapter 2 historical, cultural, legal, ethical considerations. So anywhere we go right now, it has testing and assessment. The information that they gathered from us is sensitive, that is why we should be able to know our rights as a test taker. As prescribed by the standards and in some cases by law, some of the rights that test users acquire to test takers are the right to: number 1, the right of informed consent; number 2, the right to be informed of test findings; number 3, the right to privacy and confidentiality; and number 4, the right to least stigmatizing label. So first, let us discuss the right of informed consent. Test takers have a right to know why they are being evaluated, how the test data will be used, and what, if, or any information will be released to whom. So yung mga test takers daw, may mga karapatan sila kung bakit may karapatan sila para malaman kung bakit sila yung napiling participants o yung sila yung napiling sumagot sa given na test or assessment. Pero din silang karapatan na magtanong kung saan gamitin and kung ano yung information o data na kukunin sa kanila at sinong makakaalam ng mga ito. With full knowledge of such information, test takers give their informed consent to be tested. So dapat yung mga test taker ay fully knowledge about sa test na gagawin sa kanila before sila magpirma ng consent. Test takers as young as 2 or 3 years of age or an individual who has intellectual disability with limited language skills. A disclosure before testing might be worded as follows: I'm going to ask you to try to do some things so that I can see what you know, how to do what things you could use some more help with. That is according to APA 1985. So, dito sa the right of informed consent din, we should have the rights to know the assessment before we take it or we give our consent. Consent is a document in which it states the general purpose, the specific reason or goal, why we need to do the assessment, the instruments to be used in conducting the testing or assessment also. The privacy and confidentiality is also included in its limits, risk and benefits of the assessment, the fees, if applicable pa ba, and most especially the rights to withdraw sa ika-conduct na test. The rights to withdraw states that we have the rights to stop the assessment anytime, and the assessor should respect it, for it is our rights as a test taker. For example, you're being uncomfortable na sa ginagawang test sa iyo, and then if naka-decide ka na you want to stop, you have the rights to tell to the test assessor, to the assessors that you should withdraw or stop the test. Competency in providing informed consent has been broken down into several components. Number 1, being able to evidence a choice as to whether one wants to participate. Number 2, demonstrating a factual understanding of the issue. Number 3, being able to reason about the facts of a study, treatment, or whatever it is to which consent is sought. And number 4, appreciating the nature of the situation. MacArthur Competence Assessment Tool Treatment, also known as the MAC-CAT-T, which consists of structured interviews based on the 4 components of competency listed above that yields information and decision-making competence. If a test taker is incapable of providing an informed consent testing, such consent may be obtained from a parent or legal representative. Consent must be written in rather than oral form. The written form should also specify the general purpose of the testing, the specific reason it is being undertaken in the present case, and the general type of instrument that to be administered. So if hindi capable yung test taker na mag-give ng consent sa testing, consent ay pwede makuha from a legal representative or as a parent. Tapos yung nilalaman ng consent dapat the general purpose is present, kung bakit kung yung rason kung bakit i-conduct yung test or yung assessment, and then kung anong instrument pa yung gagamitin sa pagkuha ng data. The signed informed consent is very crucial for both the assessor and the tester, for it is a protection in case anything happened. There is a written report that has been signed. For example, you discover that the data that has been gathered from you was being sold by the assessor, and there is no consent from you, you can complain to them. And then a reminder that we should read every consent that we are going to sign for us to be aware and knowledgeable about the thing that we are entering. And decide naman sa mga assessor, maybe we if maging assessor man tayo in the future, we should explain the content of the assigned form. Ideally, we should discuss it to them word by word clearly to prevent problem during or even after the assessment. The right to be informed of test findings. In bygone era, the inclination of many psychological assessors, particularly many clinicians, was to tell test takers as little as possible about the nature of their performance on a particular test or test battery. Test takers have a right to be informed in any language they can understand the nature of the findings with respect to a test they have taken. They are also entitled to know what recommendations are being made as consequence of test data. With sensitivity to the situation, the test user will inform the test taker and the parent or the legal representative or both of the purpose of the test and the possible limitations and margins or the error of the test. So after the assessment, there should be result. Syempre may result talaga. And one of the test takers' right is for them to be informed about the results since it is their data and the assessor should give it to the client. Usually, in psychological assessment, as what I have researched, results are not given or even the report. It is not that simple and advisable to give the results immediately because there might be a chance that the client may misinterpret the results or they don't have a background or of idea about the results. For example, the psych results are given to a social referral, for example, a guidance counselor. Once who referred the client was a guidance counselor, so the report must be written or addressed to her and give it immediately. So number 3 was the right to privacy and confidentiality. The concept of the privacy right recognizes the freedom of the individual to pick and choose for himself the time, circumstances, and particularly the extent to which he wishes to share or withhold from others his attitudes, beliefs, behaviors, and opinion. Privilege is the information that is protected by law from disclosure in a legal proceeding. Statutes have extended the concept of privileged information to parties who communicate with each other in the contents of certain relationship. Privilege is extended to parties in various relationships because it has been deemed that the parties' right to privacy serves a greater public interest than would be served if their communications were vulnerable to revelation during legal proceedings. Confidentiality may be distinguished from privilege in that, whereas confidentiality concerns matters of communication outside the courtroom, privilege protects clients from disclosure in judicial proceedings. Privilege in the psychologist-client relationship belongs to the client, not the psychologist. In some rare instances, the psychologist may be ethically, if not legally, compelled to disclose information if that information will prevent harm, either to the client or to some endangered third party. A complicated law, which is the Data Privacy Act of 2012 in the Philippines. This law is complicated, but basically the goal of this is protect the information of the data of the Filipino. So how can they protect it? Number 1 is the informed consent. Yun nga, yung informed consent yung pinaka-importante. There are penalties when this information have been shared to public without the consent of the client. Basically, an individual's data are private and not available for public unless the individual makes it to public. Test results are a form of data. Hence, the test takers have the right to make it private and the assessors have the responsibility, sila yung may responsibility for it to be kept confidential and private. There is also a limitation of right. There is a limitation of right to privacy, which is usually the data or the information that have been disclosed is more likely to harm an individual or in near danger, and they should be referred to. For example, lumabas sa assessment or interview that there is a high chance for the person to perform a suicide or danger or even harm his or himself. In that case, there is what they call a duty to warn, which means that the assessor needs to inform the persons associated with that the client has a high chance of involving him or herself in danger. In short, if there is a high possibility of danger, the right to privacy will end. The right of confidentiality and privacy will also end if the court requests for the data or even requests for a subpoena to the assessor, and in which this usually happens when the client has been involved in a criminal case. So, ethical issues when third parties observe or participate in assessment. Two necessary parties to any assessment are an assessor and an assessee. A third party might be an observer, supervisor of the assessor, a friend, or relative of the assessee, a legal representative of the assessee or the institution in which the assessment is being conducted, a translator, or someone else. Ethical questions have been raised regarding the extent to which assessment data gathered in the presence of third parties is compromised due to a process of social influence. Another important confidentiality-related issue has to do with a psychologist must keep confidential versus what must be disclosed. Another ethical mandate with regard to confidentiality involves the safekeeping of test data. So, dapat yung mga data is secured, walang makakaalam, walang ibang access nito. Dapat secured na yung mga data na nag-gathered natin sa ating mga test takers. So lastly is the right to least stigmatizing label. The standards advise that the least stigmatizing labels should always be assigned when reporting test results. To better appreciate the need for this standard, consider the case of Joanne Iverson. So let me read to you the case of Joanne Iverson. Joanne was 9 years old and suffering from claustrophobia when her mother brought her to a state hospital in Blackfoot, Idaho, for a psychological evaluation. Arden Franson, a psychologist employed part-time at the hospital, conducted an evaluation of Joanne during the course of which he administered a Stanford Binet intelligence test. In his report, Franson classified Joanne as a feeble-minded at the high-grade moral level of general mental ability. Following a request from Joanne's school guidance counselor, a copy of psychological report was forwarded to the school, and embarrassing rumors concerning of Joanne's mental health condition began to circulate. Joanne's mother, Caramel Iverson, brought a libel defamation suit against Franson on behalf of her daughter. Mrs. Iverson lost the lawsuit. The court ruled in part that the psychological evaluation was a professional report made by a public servant in good faith, representing his best judgment. But although Mrs. Iverson did not prevail in her lawsuit, we can certainly sympathize with her anguish at the thought of her daughter going through life with a label such as high-grade moron, this despite the fact that the psychologist had probably merely copied that designation from the test manual. In the case of Joanne Iverson, what the psychologist did was right naman. He just conducted the test and delivered the test results. It's just that he's the way how he labeled the student as a high-grade moron led to a big issue na napunta pa sa lawsuit. But then we should be always we should at least be stigmatizing, let us avoid using mental conditions as an adjectives. In a test score have their one word. For example, in an IQ, if an average IQ of an individual is a 90 to 109 in an SB, then the interpretation here is average. IQ tests have uploaded their test results and scores. Yung sabi ko nga, if label will be used, it should be least stigmatizing. Let us avoid using mental conditions as an adjectives. Instead of saying depressive patient, autistic, schizophrenic. We can use clients suffering from depression, child with autism, patients suffering from schizophrenia. That's what I've learned from sa mga na-research ko po and sa mga na-watch ko na video. We should always be aware of this as a test taker or a test user, for the data that have or will be used is sensitive. Then advise that least stigmatizing labels should always be assigned to when reporting test results. So, yun po. Thank you.